Okay, so now I'm going to toss it over to Gail for the data privacy implications of all of this.
Thanks, Peter. So I think we can move to the next slide. Just listening to everything we've talked about so far, I think the takeaway, even if you're not really a tech person, is that we're talking about huge volumes of information, huge amounts of data being collected by cameras, in many cases just passively, nobody having to do anything. These things just run and record data. And the reality that these are being used in many cases by law enforcement, that they're being sold, the data is being sold. There really aren't a lot of limits or anything around here saying this is the permissible uses or any kind of things reining it in. And we mentioned some examples, but there are data privacy laws out there that in a variety of cases impose limits. So for example, the GDPR, which whether or not you're covered by the GDPR is a different question, so it wouldn't necessarily apply to this, but just thinking through the GDPR framework, to collect certain data, you have to have a legitimate permissible use that you have to share with people. Also significant under the framework of the GDPR is that geolocation information is considered an elevated level of personally identifiable information, where you need an even higher level of explanation as to why you're collecting it, and there are even more intense restrictions over its collection, retention, and deletion. Similarly, we see that in the CCPA in California, geolocation information is similarly called out as an extremely sensitive type of data that has to be treated with, I would think, increased focus and sensitivity. And we see that as well in the SHIELD Act. And to your prior question, Ron, I think you mentioned the issue about whether these privacy statutes would apply to the government. My understanding is the SHIELD Act would not apply because it doesn't apply to states. So it broadly applies to entities that either have or lease, own or lease personal information of New York residents. And that would include geolocation information along with other information. Important to know about the SHIELD Act is that you can be covered by the SHIELD Act even if you don't have a physical place of business in New York State, as long as you're collecting or owning or leasing. And again, we haven't seen a real definition or an example of what leasing is, so that's a very broad term intentionally as well. You could fall within the SHIELD Act even if you're not physically doing business in New York State. So it raises an issue if these laws really would capture the state action part of it, but to the extent that you have these private actors in this space, collecting this data, in some cases managing the data, selling the data, these privacy laws would apply to those entities. So Ron, thoughts on that and the role of whether or not these laws might govern the government action, police?
I don't see how any of these statutes that we've been speaking about here really are going to be able to regulate what government is doing. Unless the statute specifically says you can't do X, you can't do Y. And a good example of that now, Gail, you mentioned before we speak about facial recognition technology. Portland, Oregon has banned the use of facial recognition technology by government agencies in Portland, as well as now by private companies. So as we're dealing with this type of information, we have to look to see what laws might apply to it, whether our client or we, if we're collecting the information, fall within the scope of the statute. So that's number one. We're going to see a number of laws doing things different ways here with private entities. And if the statute says we're going to regulate the government, like the Portland ordinance did, then it's going to regulate what government can do. But I think the big key with this slide you have up now, Gail, and look at the points of concern that entities need to think about. First, what do you collect? Pretty simple. These license plate readers, you collect everything. Whether you should or should not do it is another issue. Retention's something we've been alluding to throughout the entire hour or so. How long do you keep this stuff? And some statutes now have what we call minimization requirements, basically saying you keep it as long as you need it and then you get rid of it. And we can have a giant debate about what that means. Then access, who gets to look at it? And last, sharing. And sharing, I think, Gail, was really a nice way to say who do you sell it to in
Right.
this space. So
And
I'm sorry, go ahead.
yeah, I think that's important, and I would think that even if these privacy laws don't apply or can't be enforced against government actors specifically, it's wise for anybody who's using this technology, certainly private entities, because they would be subject to the laws that we mentioned and others, but also government entities that are using it, because I think when some of the abusive cases come out, like police officers, stalking their love interests or things like that, there's a backlash because it hits to what you call the creepy factor, Ron. And, as we get to a world where people are starting to be more concerned about privacy, there could be action taken. So we just suggest that if you're in this space at all, you're using this, you should have a collection policy. As Ron mentioned, you should ask, are we going to limit this only to data that that we get a hit on? Maybe we're not going to save everything. And I think that was the ACLU's recommendation in a report that they did. There's no reason not to only keep hits. If you're looking for a hit, like a match, and that you're going to use for some criminal, litigation purpose, save that, automatically delete the rest. Why do you need everything else? The implication being that you're keeping everything else because you want to create that mosaic. You want to create a pattern over time. You want to have all this information around. And while we're talking about privacy, I think another important thing is security. If you want to keep all this information, which arguably is not relevant, you weren't intentionally looking for it, you don't have any kind of reasonable suspicion or any pending crime that you're aware of that you're looking for this person for, if this information is breached because you haven't secured it properly, there's going to be an issue. And again, while the SHIELD Act might not apply to state actors, it's important, like the SHIELD Act has all these reasonable cybersecurity measures that include minimization, as Ron mentioned, and also the security that you have to have in place to secure sensitive data, which arguably this information, if you talk about images that have pictures of people, other identifiable information, may fall under. So again, it may be one of these things, less is more. We may get to a point where a government entity or a private company may have to explain why they made the choice, not just to keep matches, not just to keep hits, but to keep everything, or to broadly send that car out to search, to record every license plate with no basis or pending litigation.